Assalamu alaikum wa rahmatullahi wa barakatuh. Good evening and welcome to Legal Ease, the show that converts legal jargon into legal Eve. Juma Mubarak to everybody at home. Thank you very much for joining us once again. If you've been following Twitter and Facebook, you will know that the reason for the title of tonight's show is a little bit of a play on the words, but it's called Bogus Eventualis. And as you've obviously known by now, it's a play on the term Dolus Eventualis, which is a legal term on which we're going to get a little bit more explanation from our in-house guest. Tonight we're going to be looking at criminal law, the state of criminal law in South Africa. We've just come out of a very huge trial within South Africa. In fact, the world over. We're obviously talking about Oscar Pistorius. We're going to be looking at slightly the interpretation of the judgment in that case, and obviously then the sentencing, what it means, the correctional supervision, what that means, and correctional services generally in the country. We're going to be drawing parallels from that to another very high-profile case that is on our shores, that of Shrin Devani. Of course, the Indian businessman who is essentially charged with being a conspiracy to the murder of his newlywed wife, Annie Devani at the time. We're also going to be looking at culpable homicide just in comparison to Oscar Pistorius, specifically relating to sentencing, relating to how the presiding officer applies his or her mind in a case like that. To help us tonight, we are talking to Advocate Deon Pool. He's an advocate of the High Court of South Africa and a member of the Johannesburg Bar Council. But what's very important is that Advocate Pool was formerly a presiding officer, a magistrate in the regional and district courts around Johannesburg, around South Africa. Very, very important for our discussion tonight. Let's turn now and welcome Advocate Deon Pool. Advocate, thank you so very much for joining us again.
Good evening, Nadeem.
I'm glad that you accepted the invitation. Our show with you the last time was very well received, so thank you very much. Our viewers will remember that at the start of Oscar Pistorius, or as it just was getting underway, we had Advocate Deon Pool in chambers in the studio. At that time he was still a pupil. He's now passed the pupillage exam and is now a fully fledged member of the Bar Council. So let's get into it. Let's start talking about what has just happened in this country regarding Oscar Pistorius, and we'll take it from there. Advocate, you followed this case relatively closely. I know that, in fact, I don't think there is a lawman in the country that wasn't sort of intrigued by the case. And I think that somewhat to our disappointment, somewhat to our glee, but there's also been a lot of comments and a lot of misconceptions that have been created from this Oscar Pistorius case, which I think is a good time to put to rest now that it's ended. 7 months has gone by. It's literally gripped a large percentage of the world. Pretoria came to a standstill in the days where he was appearing in court. It was actually quite ridiculous, but it's done.
Yes.
Let's look at, just very quickly, the title of the show, Bogus Eventualis. Talk to us very quickly about Dolus Eventualis. What is it, just in a nutshell, and when interpreting the judgment of Judge Thokozile Masipa in the Oscar Pistorius case, did she get it wrong, and what is the effect?
Nadeem, Dolus Eventualis is basically just the Latin term for intention with the possibility of, or foresight, rather. You get three different kinds of intention. You get the intention, direct intention, you get intention with, or indirect intention, and then you get the one that seems to have everybody tripping up, the one where you have the ability to foresee the action that, or at least the consequence of the action that might flow from it. As far as the judgment of Judge Masipa is concerned, and there are people on the one side that says that she got it wrong, there are people on the other side that say that she got it right. To a certain extent, I am not quite sure, but I believe that the judge interpreted the aspect of Dolus Eventualis based on the version of the accused, and on that version she found that she could not find intention specifically on his part. Thus, she didn't need to go and deal with whether he had the foresight of the cause of the consequence of his actions. And she brought herself to find that he acted negligently under those circumstances.
So what you're saying ultimately is, and I'm glad you framed it like that, because it's actually a very nice way to put it, is that you're almost saying that it's not really so important whether or not her definition or her understanding of the definition of Dolus Eventualis, when explaining it the way she did, was so important, because what was important was that she did find that he did not have the intention out and out. and hence he was then guilty of the negligence aspect.
I would think that it's more a question of that she did not find that the intention was proved beyond a reasonable doubt.
Okay.
And on that, when she then moved away from the state's case, because the state has a burden to prove beyond a reasonable doubt what they allege, the state alleged intention. They couldn't, according to the judge, they couldn't sufficiently convince her of the fact that he had intention. And then you then go, and she then went to the accused version, as I interpret her judgment, and then found on his version that he acted, but that action was negligent, and that he necessarily could not have had intention in that regard.
You see, if you zone in onto the judgment and to that one line where she says, I find the accused not guilty of Dolus Eventualis because he could not have foreseen, or that he did not intend, he could not have foreseen that it was Riva Steenkamp behind the door, or that in killing her, he didn't have the intention of killing her specifically, making a subjective test as to who the target of the action was. And I think that's where the error comes in. Is that right?
Depending necessarily, once again, taking into consideration that we're reading this off a judgment, I don't think there's so much an error as there might be a misstatement as to the elements of intention in this regard, and in intention as in the Dolus Eventualis principle.
Okay.
We need to consider that the judge did not say that Oscar did not intend to kill, or the judge might have said that Oscar did not intend to kill Riva specifically, and by implication thereof exclude any other human being that might have been standing behind the door. The judge found that irrespective of who was standing behind the door, the manner in which Mr. Pistorius had acted under those circumstances was negligent and was not intentional. So whatever the result is that flowed from that, eventually would then be a result that flowed from from negligence rather than intention.
When a presiding officer, and you can put yourself in the shoes of a presiding officer, but when a presiding officer, because you've been that, when a presiding officer is dealing with such a final charge, or such a final conviction, or possibility of a final conviction like murder, and we know that it is, as you say, they have to apply objective tests and they have to be completely impartial. But what goes through the mind of a presiding officer when sitting on that chair? And what will that presiding officer be looking at? What will they be taking into account? You mentioned earlier, we talked of nuances. What is the totality of her mindset at that time?
Look, any presiding officer approaches any case that they attend to with the utmost objectivity as far as humanly possible is concerned, devoid from any emotion, because presiding officers don't have the luxury of deciding matters on emotion. And to a large extent, presiding officers are trained in order to have that mindset. So irrespective of your personal opinions about the accused or the matter or the defense, whatever you've read in the newspapers, you have to go and sit there and look at everything, not in a vacuum, but as holistically as you possibly can. And then considering that at the end of the day, you are the person in the arena. You are the person that is sitting there every day looking, experiencing the accused, experiencing the defense, experiencing the witnesses. And you eventually, from my days of being on the bench, you develop a kind of a feel for the case. And that feel, not that it's an emotion, but you have an idea as to what you can rely on, what you can't rely on. And the law gives you the tools with which you then apply that reliance of yours at the end of the day.
Let's look at now the end of it, and what would the state be wanting to do? We talked a little bit, or should I say, in the news, in the media, the Twitter, there's this whole thing of setting a precedent. Does that apply in a case like State versus Pistorius?
Any case that's dealt with before the High Court necessarily sets a precedent. What is important to note is that State versus Pistorius, if it's not appealed and it stands as it stands, and it's the judgment of Judge Masipa in this regard that we take notice of, it's highly unlikely that any legal practitioner who is worth his salt is going to rely on the decision of this justice when the appeal court in South Africa and even the constitutional court, to one extent or another, have made certain pronouncements and have given direction as to Dolus Eventualis and how it should apply and what the definition of that is. So the Supreme Court of Appeal judgments trump Justice Masipa's judgment, and it's not a precedent as far as the application of Dolus Eventualis is concerned, because there are higher courts that have decided that point in general and in instances similar to this.
So the question then comes up is, should the state appeal it, and if so, why?
Under the current dispensation, the only time that the state can appeal a criminal matter is necessarily if they are of the opinion that there has been a misdirection on a point of law. Right. Now, in this instance, the state can appeal the decision because they are of the opinion, and Mr. Garinel has made this quite clear, that they are of the opinion that Justice Masipa did misdirect herself as to the application of the Dolus Eventualis rule.
Correct.
And that she should have convicted Mr. Pistorius of murder.
Correct.
If they do appeal it, it's their prerogative to appeal it. Necessarily, it will go to the SCA. And at the SCA, as I said, the Supreme Court of Appeal has decided on Dolus Eventualis, has decided on the application of that rule, the definition of that rule. And so it's technically speaking going to go and have, or going to the Supreme Court of Appeal to rehash something that is crystallized in our law to a very great extent. So I would not see any reason for such an appeal if it's just on that point. There might be other points in the judgment that the state feels are legal points that they can take, that of course some ambiguousness, but those matters are necessarily also within their prerogative. I believe that all the aspects that were dealt with in the Pistorius case are to a large extent right, and that the higher courts in our country have dealt with them on one level or another.
So there's no danger for the legal industry, so to speak, or should I say, for jurisprudence, if it's not dealt with or cured or cleared up or rectified, for argument's sake?
I personally don't think that we run the risk that State versus Pistorius is now going to become the so-called locus classicus on Dolus Eventualis, and that is going to be the only case that we ever refer.
Yeah. You see, and I tend to lean towards that completely, that opinion of yours, Advocate. Let me ask you, you've worn both hats. You've been on the bench and you're now on the other side, getting people away from the people on the bench. And do you think that the state will actually bring the appeal? I mean, looking at the mindset of sort of an advocate like Kharin, bearing in mind he doesn't act on his own. It's the NPA decision as a whole. So do you think they will?
I personally don't think they will, because I don't see the point. As I've explained to you, if the NPA does want to appeal something like this, it is necessarily taxpayers' money that they're using. It's not their own. And to appeal on this point, on the Dolus Eventualis application, to appeal on the conviction, rather culpable homicide or murder, it would not serve any specific purpose at the end of the day to do that, because we sit with case law, and we sit with sufficient case law that tells us exactly how to apply those specific principles.
Absolutely. And it's their job essentially to uphold the jurisprudence and, as you say, the element of law in the country. Whilst they have to do that, we have to uphold our obligation to our sponsors. We're going to take a very short break, and when we come back, we will continue. Bogus Eventualis, the state of criminal law in South Africa. Assalamu alaikum. We'll see you shortly.
جاءكم رسول من أنفسكم.
He was very awe-inspiring when you saw him. He was monumental, grand in nature. His face was like a moon.
He was Muhammad.
His concern, sallallahu alayhi wa alihi.
He changed the world for the better and made us better creatures. Oh Allah.
When something, a hardship befalls you, it is so great upon his chest and heart. He cannot bear it.
The man who got sent as a mercy for mankind and for all that exists.
He's caring about all of you. He's kind and caring.
He was Muhammad sallallahu alayhi wa sallam.
It's dear to his heart what people go through.
Muhammad, mercy upon mankind, teacher of all mankind.
وما أرسلناك إلا رحمة للعالمين.
IBO is now expanding by popular demand. From October, our wide selection of famous brands will be available in Springfield Park Value Centre, Durban. We'll be stocking everything from shirts, pants and footwear at the best prices. Not only that, but we'll be giving away 1,000 pairs of shoes on our opening. So come to Springfield Park Value Centre, Durban for our grand opening. IBO, International Brands Outlet.
SA's leading bathroom design store, offering exclusive products and the world's leading brands in sanitary ware, taps, tiles and bathroom fittings. Why settle for less when you can have the best? We offer value for every budget. Visit our exclusive showrooms to experience why we are different. Exclusive brands, customer service, variety, value and backup support. Classic trading, luxury bathrooms.
Welcome to Dada's Motorland, South Africa's premier used exotic sports car dealership. We stock only the best from BMW, Mercedes-Benz, Porsche, Ferrari, Lamborghini, Aston Martin, Maserati and much, much more. So if you have the need for speed, come into one of our branches and select the vehicle of your choice. With dedicated staff to ensure your satisfaction, there's no better place to get the wheels of your dreams. Dada's Motorland.
Throughout history, there have been many champions of flavor and taste, but Jimmy's still reigns supreme. Our Killer Grill's menu boasts the sauciest steaks, spicy and tender chicken dishes, beef burgers. We are leaders in explosive and flavorful taste experiences, resulting in amazing journeys of delight. Try us for our superior taste, adding excitement and zest to your life. New restaurants open countrywide. Jimmy's Killer Grills, the addictive taste.
Assalamu alaikum, welcome back to Legal Ease. If you've just joined us, we are sitting with Advocate Deon Pool, Advocate of the High Court of South Africa and a member of the Johannesburg Bar Council. We are talking Dolus Eventualis, the title of the show, the state of criminal law in South Africa, and we've just been discussing the interpretation of the judgment of Judge Thokozile Masipa, what it means, what the state may or may not do, and we're looking now, Advocate, at a little bit of a comparison, and what I want to deal with is the judgment itself, all right? The judge found that he was guilty of culpable homicide on the one charge and on the firearm charge on the second, it was actually first was the, culpable homicide the first, and the second one was the firearm charge.
Firearm charge, yes.
Discharging the firearm at the Tasha's restaurant. Now, If we look at, okay, now let's just jump a little bit ahead and look at the sentence that was given. Okay, so Oscar Pistorius was sentenced in terms of section 276.
1I.
1I. Talk to us about that very quickly, and then I'm going to ask you about a couple of other relatively high-profile cases in the country that dealt with culpable homicide and what the punishment for that, or if there was a conviction, and what the punishment for that was. So just talk to me of 276(1)(I).
Section 276(1)(I) of the Criminal Procedure Act is basically where an accused is incarcerated. The maximum sentence, as Judge Masipa indicated, is 5 years imprisonment. And the sentence is then dictated to by Section 276(1)(I), which indicates that an accused will serve a sixth of that sentence, would then, in Mr. Pistorius' case, would be 10 months, after which he would become eligible to be placed on correctional supervision, and that discretion lies with the Director of Correctional Services.
See, that's very important, because another misconception that's come out of this is that he's only going to serve 10 months and then he's going to be paroled.
No.
So let's look at parole, because that's a completely different kettle of fish.
Yes, no, there's 276(1)(I) has got nothing to do with parole. Parole is something completely different.
Okay.
276(1)(I) also doesn't make any, has got no room for parole. You serve a sixth of your sentence. During this period that you are in prison, like the 10 months now with Mr. Pistorius, there are certain programs that he will have to do. For each of these programs that he completes successfully, he will be given a point, for lack of a better description, and at the end of the 10 months, they will basically look at how he's behaved himself, to what extent he's cooperated with the authorities, and look at the points that he's now gotten in that respect, and then he will be considered for correctional supervision. Once on correctional supervision, correctional supervision would entail house arrest. It is there's a reporting factor attached to it. People can arrive at his house at 3 o'clock in the morning to come and check whether he's using alcohol. Necessarily won't be able to be close to a firearm. There are certain various requirements, stringent requirements that are placed on him. He gets an hour a week to go and train, gets an hour a day to go to the shops maybe, gets an opportunity 2 hours a week to go to church. The rest of the time he's got to be monitored and he's got to be at home.
Advocate, it is punitive in nature. 276(1)(I) is punitive, but it's also reforming to an extent. It will put a position or an accused or a convicted person in a position where they are forced to reform. That really sounds like the motivation behind the section. Is that how you see it?
Yes, and with the added, or not the advantage, but with the added idea that it doesn't become a burden on the taxpayer.
Okay.
It is still a punitive sentence. It's a very stringent sentence. There's nothing nice about correctional supervision if the provisions of it are very stringent. You can imagine having to sit at home the whole day, not being able to go anywhere, except to go to the shop for an hour, and have somebody phone you at 2 o'clock in the morning and come and monitor you once a week. So there's nothing nice about correctional supervision in that regard. The only difference is that you are not sitting in a jail cell necessarily surrounded by four walls.
So it might be a better position, but it's certainly not a good position.
No.
If we want to talk to the two sides of the fence, you've got some viewers and some people in society saying, way too lenient, he should have been dealt with the full extent of the law. And you have others saying, well, listen, you know what, 10 months is still a bad deal. And that's where the misconception comes, because it's not just 10 months.
No.
Because if he doesn't pass the first 10-month assessment, he goes into the next 10 months and he's assessed again.
Yes.
And he'll continue to be assessed until they find him eligible for correctional supervision.
Look, the whole point of 276(1)(I) is that the accused, to a certain extent, has got his fate in his own hands. So he is the person, he's the captain of his own demise or success in this regard. If he doesn't behave, he doesn't become eligible, and he will sit for the whole 5 years if it comes to the push. It also needs to be considered that we must all just remember that as far as the specifics of the sentence is concerned, that Mr. Pistorius was convicted of a negligent act.
Right.
In other words, the court accepted that he made a mistake and that mistake is culpable. Right. And it's based on that decision of the court that he was sentenced. He's not being sentenced as a convicted murderer.
Right.
He's been sentenced as somebody who acted negligently under a set of circumstances where the law required him to act better.
Yes.
So the degree, of his negligence is what the court necessarily would take into consideration when giving him a sentence which it finds appropriate.
Yeah, and that's precisely true to the point, because the sentence in this instance fits the conviction.
I believe so.
And is relatively, and I completely concur, is reasonable considering what she decided in terms of his conviction.
Yes. Whether we agree
on the judgment or not is irrespective.
Yeah. Whether we agree on that or not is irrespective, as you say. The fact is he was convicted of a negligent act, and the sentence, I'm of the opinion, is an appropriate one.
And I concur with that sentiment. Looking, however, at some of the other incidences where there have been charges and maybe convictions of culpable homicide. Let's look specifically first and foremost of the former Blue Bulls rugby player B.S. Roo, mountain of a man who happened to kill a Metro cop with his bare hands after being pulled over. There were some other elements to the story, but that's the gist of it.
Yes.
There he received a full correctional supervision, if I'm not mistaken.
Yes.
Talk to me to the difference. Why would that have been applicable? And we don't perhaps know the facts of the matter completely, but
shortly, the facts of the B.S. Roo matter was that he was coming home one night, and he was stopped alongside the road, and the Metro cop alleged that he'd been drinking. And according to his version, the policeman got into the motor vehicle next to him and was planning to hijack him or something to that effect. He then reacted under those circumstances, which eventually led to the death of this policeman.
Right.
The main distinction between Mr. Roo's case and Mr. Pistorius' case is that B.S. Roo never went on trial. He entered into a plea agreement with the state, in which instances the prosecuting authority agreed that he acted negligently, that he acted with culpability and thus culpable homicide, and they also agreed on the appropriate sentence, which in this instance was a sentence of complete, I think it was a suspended sentence, suspended sentence. He was, however, ordered as part of the conditions of that sentence to pay 750,000 rand as compensation to the police officer's family, which he did.
Correct.
And but understanding that the court accepted the agreement that the accused in that instance had entered into with the state. And for that reason, Mr. Roo was convicted of the culpable homicide and got the sentence that was eventually passed on him.
If Oscar Pistorius had come to the state, hands out, and said, look, I've committed a grave error, I want to plead this out, do you think his sentence could have been different?
I think the sentence to a certain extent could have been different if the state was amenable to accept a lesser plea of culpable homicide. I'm sure that his defense team, Advocate Barry Roo, and the whole Oscar Pistorius defense team might have suggested a more lenient sentence, but something more non-custodial in that instance. They might have even taken cognizance of the B.S. Roo matter and offered a certain amount of compensation to Ms. Steenkamp's family.
Monetary, yes.
And if the state had accepted that, that could quite possibly have been the sentence.
And I don't want to jump the gun, but I have no doubt that that offer was most likely made. I'm pretty sure that the state might have just rejected it. I'm sure that those negotiations must have taken place somewhere along the line.
I also believe that you know, considering the level of expertise in Mr. Pistorius' defense team, that they would have approached the state at some point in time with a specific plea agreement in mind, and that the state would have not taken any notice of it. I think mostly because of the high-profile nature of the case, they wouldn't want to have been seen partisan to any effect, and necessarily for whatever other reason. But I do feel that that would be the first port of call under these circumstances. There are certain facts that stand and that existed right from the start.
Which were risky at best.
Which were risky at best, and I think that considering who the people were that were defending him, that would have been their first port of call.
Okay. I'm going to ask you just one more question. Then I'm going to open the phone lines. I mean, tweets are coming in. The phone calls were ringing prior when I put the show up, and people are wanting to ask questions on this issue. So before we do that, we'll go for a quick ad break, and then we'll come back. And when I come back, I just want you to draw a parallel for me to another incident where an accused person, in that case, was then was involved in the killing of a family member. In this instance, it was the Fasakhi matter, and where he shot his daughter. Ponder on that while the viewers are doing that. We'll go for a quick ad break, and we'll come back. And when we come back, we'll deal with that, and then we'll jump to the Shin Divani matter and look at that a little bit, as well as take some questions. Jazakallah for staying with us. We'll be back very shortly after this ad break. Assalamu alaikum.
Global Flooring. We specialize in porcelain tiles, wall-to-wall carpet, laminated flooring, and moss carpet. Allow us to design, supply, and fit your own personalized masjid carpets. Come to us for the lowest prices without compromising on quality. Visit us at number 10 Stella Avenue, Crown Mines, Johannesburg. Contact us on 011-8300-55203. Email global@mweb.co.za. Visit our website at globalflooring.co.za.
Adega, an upmarket Portuguese restaurant that offers a unique and memorable dining experience. The restaurant offers a warm ambiance and was voted Best of Johannesburg, Best Portuguese Restaurant for 7 years running. We aim to provide the best quality food and service. Make your booking today and enjoy fine dining at its best. Adega Restaurants, always open, always good.
Once in a lifetime prices at Lindsay Saker Moy Street. Get our cars at staff prices, like the Polo 1.2 TDI Blue Motion for 205,000 Rand. Or the Polo GTI with sunroof and xenon lights for 288,000. Or the Polo Sedan 1.4 Comfort Line for 184,000 Rand. Or the Golf 7 GTI with sunroof and xenon lights for 399,995 Rand. Lindsay Saker Moy Street.
Spice Mecca's newly packaged spices, categorized by spicy orange, exotic red, natural green, and magical purple. Use our blends and seasonings, masalas, herbs, or pure ground and whole spices to create yet another unforgettable taste experience. Choose your color, choose your number. We have your taste. So come on, do it the Spice Mecca way, the cook easy way.
Looking for the ultimate burger? Oh, yeah. To curb that craving 100% with 100% real ingredients, 100% freshness, 100% flavor, 100% choice, 100% quality, 100% purple. Unwrap a smile at Purple Burger.
Lifestyle Ceramics. Design your lifestyle.
Assalamu alaikum, welcome back to Legal Ease. We're talking bogus eventualis, the state of criminal law in South Africa. We've just discussed culpable homicide, we've just discussed the sentencing, whether appropriate or not in respect of the Oscar Pistorius case, so State versus Pistorius, as it will now become known within the legal world. And we're talking to Advocate Deon Pool, as I mentioned before, an advocate of the High Court of South Africa and a member of the Johannesburg Bar Council. His details appear at the bottom of the screen. Should you have any queries or inquiries from a legal nature, or you wish to brief him, some of the attorneys that are watching the show, I can tell you from experience he is a formidable force in South African courts. Advocate, I was asking you just before the break, I was talking to you about Fasakhi, and I said that's another incident where a family member was killed by another family member, in this instance the accused, but very different circumstances, and the way the state looked at it was also very different. What happened there?
Well, you will remember that Fasakhi was the gentleman who accidentally shot his daughter when she was coming home from a date at 2 o'clock in the morning, thinking that she was a burglar. Mm-hmm. That matter was withdrawn by the state, and I believe that it was withdrawn for the simple reason that although his actions were wrongful, although his actions might have been considered to be a crime, The state basically took the position that there is no possible sentence that any court could deliver on Mr. Visagie that would be a harsher punishment than the fact that he had lost his child and that he was the reason for that. Because necessarily under those circumstances, no parent survives the death of a child. And I don't believe that you survive it even more if you were the cause of that.
Yeah, and I think that, and if I can remember correctly, he suffered a severe spate of PTSD, and he, in fact, from what I remember at the time, he still hasn't really fully recovered. I mean, he undergoes psychosomatic testing on a regular basis. I mean, you're quite right in your statement that there is no way a sentence could have been harsher than that. In fact, probably death would have been the only possible sentence that he would have wanted to get away from what he'd done. We're going to open the phone lines now, Advocate Pool, and we're going to take some questions because there are a lot of questions that people want to ask regarding this, and also the Srin Devani case, which is currently going on in our courts. They are on their 10th witness already, the state. So they relatively quickly, it's only started just over a week ago, and they broke only for Diwali because both parties...
it's wonderful what a difference not having a thing televised makes.
Unbelievable. And, you know, we spoke about that when you... Let me quickly confirm. So the phone lines are open. The number to dial, as you always know, 011 086 7700 or 1 or 2 or 3 appears at the bottom of your screen. Like always, you can also tweet or post on Facebook. It is Legalese on ITV, that's a Twitter handle, or Legalese ITV /Facebook. I think that's about right. Anyway, so let's go back to that. Srin Devani. I was saying just before that the issue of dealing ultimately with the issue of how the state thinks about a matter and how they apply different circumstances to a different case, and every case has its own circumstances.
Yes.
You won't go to, a legal person wouldn't go and say, well, look at what happened in the Visagie case. You should give Oscar Pistorius a lighter sentence. Not the same thing at all. So
look, necessarily, the Visagie matter is a case that. It's the decision that was made there is humanitarian in its nature. I had a similar matter when I was presiding as a magistrate where a lady reversed out of her driveway and accidentally reversed over her 3-year-old son who was playing behind the car at that point in time. Her actions are negligent because necessarily you have to take notice of what's going on behind your car. But the issue was there once again. There could not be a possible sentence that I or any other court could have visited on her that would have made any impact on that woman at that point in time, because she was absolutely devastated, and rightly so.
Absolutely, it makes sense. Let's look now. We just made a comment now with regards to how much more smoother and how much quicker a trial will go without the interference of TV cameras. Remember when we first interviewed, we spoke about the potential pitfalls of having those cameras in the Oscar Pistorius case. And one thing that really didn't come up as much as I thought it would was that other witnesses, and I posed this question to you already when we interviewed you the first time, other witnesses are going to be looking at the testimony of other witnesses. And witness testimony in its own self should be confidential. It only was mentioned once by Barry, but not with enough venom that the court would sit back and say, well, listen, he's got a point. Looking at the Srin Devani matter now, witnesses have become a crucial element. We just know that Zolile Mngena, who was the trigger man, died last week Saturday from a brain tumor. How devastating is that for the state's case?
Well, Mr. Mngena, he was cross-examined, so his evidence has been tested.
Right.
And it stands.
Okay.
So there's the evidence is on record. If he had necessarily passed away during the course of his cross-examination or during the course of the evidence in chief, if in the evidence in chief he passed away, then his evidence would have to be excluded because it had not been tested. If he had passed away during the course of cross-examination, then only that part of his evidence that had been tested would have been admissible. The rest would have to be excluded.
Okay.
But his evidence is on record. Mr. Devani's attorneys or counsel has had an opportunity to cross-examine him, so it stands. The fact that he's no longer with us has got no impact on the relevance or the admissibility of that evidence.
Certainly. The other two witnesses are still around, and they also the state has dealt with them the defense attorneys have dealt with them quite severely. One thing that always was important in this case is that they were convicted of this crime. Yes. So they've got nothing to lose or gain anymore. You know, I find that a lot of times where a witness has, a possible accused has turned state witness, that is a little bit more pressurizing, or that can lead to a witness wanting to give more than is necessary. But in the case where they've already been convicted, they're actually serving time already. Does a presiding officer look at that and say, well, they can't be lying, they've got nothing to gain? From a credibility point of view.
From a credibility point of view, it is a factor that you take into consideration, but it's not the only factor. You still have to look at the credibility of that witness. You have to take into consideration what they have said and to what extent it applies to the probabilities that you are working with, which in Mr. Devani's matter is being tested at length by Mr. Devani's defense counsel. Mm-hmm. So the mere fact that a person has been convicted of the crime that he is now testifying in doesn't per se make what he is saying to be credible. Mm-hmm. On the contrary, he can be simply just looking to get out of prison for a day or two and is prepared to go and say anything that people want him to say. To put it very simplistically, but the fact that you're serving a sentence doesn't necessarily make you altruistic.
Yeah. Just taking it back to the beginning of Shin Devani, the issue of extradition, one of the questions that was posed to me, I was interviewed on a radio station today in fact, was that the issue of the extradition, should he be sentenced? Where would he serve his time? Is there ever a possibility or provision in our law that he could be sent back for purposes of serving a sentence in his country of origin? Is that possible at all?
There is a provision in our law that could happen, but generally speaking, our law would expect that if he is convicted in a South African court, he should serve the sentence in a South African prison.
As I understand it, yes.
Our laws concerning incarceration, however, don't dictate that he can be sent somewhere else. That will be a diplomatic decision that has to be made, and that will fall under the Department of Foreign Affairs. But we do have an agreement, like we have a reciprocal agreement between ourselves and England, mm-hmm. On various levels as far as our jurisprudence is concerned. That's one of the instances where it can be allowed, but there will have to be very specific circumstances why that is considered.
Like what? I mean, would his alleged mental state, which is actually now been put to bed, would that have played a role?
I wouldn't specifically be able to answer you as to what the specific requirement would be, but general things like your mental state, your health, those aspects would not be one of those considerations. It would have to be a very specific consideration. If I can maybe think of a matter just off the top of my head, there was an instance where somebody was allowed to come and serve actually from England to come and serve a sentence in South Africa because of a specific medical procedure that he had to undergo, and that we were the only people that were able to perform it.
Okay, so it's quite extreme.
Yes, it's a very extreme set of circumstances.
Mm. One thing that Shin Devani's lawyers, and I must quickly say that, I don't know if you heard it or listened to it or watched the commentary on it, but when they dealt with the state's 10th witness, which was Engelbrecht, he is the police ballistics expert, yes. He fell apart to quite an extent. We talked about ballistics when we spoke about Oscar the first time. Again here, it appears that ballistics is important. Is it really?
Ballistics is very important when it's a gun-related offence. Mm. Specifically when you're working with a situation where somebody has been shot. In the Devani matter, the ballistics expert is being called by the state in order to prove the aspect that there was a certain action that was related to Mrs. Devani's death, and in that kind of putting the building blocks in place for them to eventually say, but we've now proved that Mr. Devani is the person that is behind this murder. Ballistics in general, as far as Mr. Engelbrecht is concerned, apparently made a mistake between the bullet belonging to an Arinco pistol and it actually belonged to some other kind of pistol, which was not the pistol that the person was shot with. So that is material, and the state will need to address that, or else their whole his whole testimony will fall apart.
So then, if his testimony falls apart, what happens to his conviction?
Necessarily the ballistics expert, you won't be able to take that evidence into consideration.
Well, I'm talking about the conviction of the gunman, of the triggerman, because isn't that where the issue is coming from?
As I understand it, and considering also that the information that we get is from the press, we now don't have a blow-by-blow account like we did with Mr. Pistorius, is that the ballistics expert on whose evidence, or necessarily who was available for the conviction of the gunman, is not the same as Mr. Engelbrecht in this instance.
Okay. Okay, well, that makes sense. I remind you once again, as always, that the phone lines are open. The number to call 011 086 7700 1, 2, or 3. We're talking to Advocate Deon Pool, and we're talking about the state of criminal law in South Africa, specifically the relatively high-profile cases that the world has turned its eyes towards South Africa to witness. Shrindivani, which is currently ongoing, and obviously Oscar Pistorius, which has now been dealt with, I think, to finality to some extent. We might see that he defaults after the first 10 months, and he might end up staying there for another 10 months, but if not, well, for now it's done. Looking at Shrindivani's case, and I was going to say this earlier, his defense team have applied a similar tactic, at least this is what the press is saying, a similar tactic that he has really put his entire self before the court. He's talked about some of his inadequacies, he's talked about some behavior with regards to male prostitutes, which was frowned upon within his society. He's talked about alcohol binges, drug binges. He's talked about the fact that there was talks of potentially not getting married, and what his society would say and what his family would say. To me, that sounds devastating towards the character of a person who's being tried, who is being charged with potentially being involved with the murder of that very person. I don't see the tactical approach. What would you say?
Look, first of all, it's very important for an accused, when you are in court and you've got nothing to hide, to take the court into your confidence, as they say, and to play open cards with the court. And I think this is what Mr. Divani, to a large extent, is attempting, is to create or to bring to the fore the impression, rightly or wrongly, that he is an honourable man, that he's full of frailties and he's fallible, and necessarily because of his traditions in his environment that he found himself in this situation. Whether that is going to stand to his benefit or to his detriment, we will have to see at the end of the trial. Once again, it's the scrutiny that this case is under. There's very little, especially considering that he comes from England, a country that is renowned for scratching everything open about your private life. Most of this evidence emanates from there anyway, from reporters getting hold of it on some level or another. And as we'll have to wait and see, to what extent this is going to impact on the eventual conviction or acquittal in this instance, whether the court is going to believe that he is simply just a man that found himself in this situation, but that he had nothing to do with the murder of his wife. He has to answer the allegations, because the state is putting the allegations and painting the picture that he was somebody who preferred the company of men by virtue of the fact that he was in arranged marriage, wanted to get out of that, and this is the only option that he saw to himself. So he has to respond to it in order to defeat that evidence, because that evidence the state is using to create the impression that he had a motive.
The phone lines, as I mentioned again, are open. Number to call 011 086 7700, and it appears on the bottom of your screen. We take your questions. How do these high-profile cases, as they are now in the country, how would they change how lawyers will approach criminal matters? Do you think that it would have a difference on the mindset of us when we're dealing with criminal matters in the future, especially regarding the fact that we're not all going to have, as you say, a blow-by-blow report where there's a TV crew and 100 Twitterati's sending status updates on a daily basis. And if you are involved in a high-profile matter, do you think that the conduct of the court, the conduct of the lawyers, do you think that has effect on the industry as a whole?
I suppose that some lawyers might necessarily take advantage of the fact that matters are being televised, or that matters are of such a high-profile nature that they are on the front page of the newspaper. But fundamentally, the practice of law is an honourable profession. And to maintain the honourableness of our profession, we've got to maintain its ethics, and we've got to maintain the manner in which we conduct ourselves. Lawyers don't get personally involved with their cases. They don't grandstand. They don't take advantage of aspects that are not relevant to the case at hand. And at all times, our responsibility lies with our client. It doesn't lie with us. Our responsibility is with our client. And I believe that at the end of the day, if you act with the necessary virtue, considering your role in society, that is what will pull you through, and not the fact that you're on the front page of the newspaper every second week.
Should Mr. Devani get an acquittal in a matter like this? Again, very close to the hearts of many. From what I understand, the courtroom was full with journalists, mostly from Sweden and from the UK. Obviously, as you know, Mrs. Devani was of Swedish origin. Does South Africa really in the limelight? Is really in the limelight? And do you think we've fared well thus far from a criminal perspective?
I think that that if there is any doubt in our law that our justice system doesn't work well, then that doubt doesn't exist if we look at the manner in which the Pistorius matter was conducted. That trial was open, it was transparent. The judicial officer, the defense attorneys, everybody to a large extent played according to the rules. We got an insight as to how a case works, what is when, how do we approach it, and there is nothing, as far procedurally, there is absolutely nothing wrong with that trial. Similarly, the Devani matter, once again, in the news, very high-profile matter, especially in the outside world and in England. They once again cannot fault us on the manner in which we are allowing justice to be served and that we are allowing the rights of the accused, as protected by our Constitution, to be adhered to.
That's a good thing for us. I mean, certainly, and for our industry. I mean, because and I can say with much satisfaction that looking at how it has developed and how it unfolded, and even with the circumstances, the very unique circumstances of having sort of TV cameras on a daily basis and Twitterers and all these things, it really hasn't been. It hasn't been a shambles at all. And I must say, I'm quite proud to say that we are lawmen and we are within this industry in South Africa. It's a good thing. As I mentioned again, the phone lines are open. Obviously, if you need to call or if you would like to call, ask Mr. Pool any questions. The phone lines are open for you to do that. Obviously, if you would like to, after the show, email Advocate Pool or contact him on his cell phone number. The number does appear, or contact him at his chambers. He's at the Duma Nokwe group in Johannesburg town. And as I say, he is extremely competent in this field and in other fields, commercial as well, and he will be able to assist you. I have no doubt of that. Advocate, where to from now, if you're looking at sort of Gerinal or Beirut, where to from now for them? I mean, they've come off a massive trials, probably one of the biggest in their careers potentially, especially from a celebrity point of view. Do they take the day off?
No, I think lawyers of the caliber of Mr. Roo, they just carry on. Tomorrow is another day. The diary is full. Same with Mr. Nell. I'm assuming that he has got other matters on his plate. He necessarily works for the National Prosecuting Authority. Doesn't just have one docket to prosecute. As you know yourself, there's very little time to consider anything. You might have a quick whiskey and then go on to the next case. Yes. And because tomorrow morning you've got another client who's depending on you to perform to the best of your ability.
Absolutely. Absolutely. Well, there you have it from Advocate Pool, former presiding officer. So he wore the hat of the man who issued sentences very similar possibly to Judge Thokozile Masipa and potentially to the judge in the Shin Devani case. And now he's on the side of those who are charged with certain crimes within our country. And as I say, he is extremely competent and able to deal with those. This has been a great show, Advocate Pool. Thank you very, very much for joining us. I must say, I'm glad that it's over to an extent because we can now continue with normal life and look at sort of normal matters that are not within such scrutiny of the society. Very big ups, of course, to Khairinal and to Beiru, our colleagues, obviously much senior to us, but our colleagues nonetheless, for upholding the industry of law. And as I say, a great presentation for the country, and something that we can look forward to in the future. Been another phenomenal showing of Legal Ease, the show that brings you the show that converts legal jargon into legal ease, and on occasion brings you expert guests like Advocate Deon Pool, who really enlighten us with his information and his understanding of the law, which is really quite astute. So thank you very much for that. Jazakallah to all of you for following us and for staying tuned. We will obviously be back next week, Thursday, on the same time slot with my co-host, Mr. Ashraf Esop, and then thereafter you'll be back with me again. Jazakallah for joining us. This is Legal Ease. Assalamu alaikum wa rahmatullahi wa barakatuh.